May it please the court, Jennifer Carr here on behalf of Progressive. I would like to reserve 5 minutes for rebuttal, please, Your Honor. Thank you. This is an appeal of an order denying a motion for new trial in an auto negligence matter. Progressive is arguing for several reasons that it was denied a fair trial in this case. The first issue that I'd like to address is the insufficient evidence of the future medical damages that were awarded in this matter. The jury awarded $292,500 for future medical expenses that were not proven with reasonable certainty. The treatment itself wasn't, and certainly the cost for those expenses was not. Plaintiff presented one expert witness with respect to her future medical treatment. That was Dr. Hall. And on cross-examination, defense counsel asked, this is on 1978 of the record, now it sounds like you can't say to a reasonable degree of medical certainty how much per year it will cost her, meaning Ms. Tran, for treatment. The answer, that would be impossible for anybody to say.
Wasn't there some rehabilitation regret?
Well, Your Honor, frankly, on when plaintiff's counsel asked, are you reasonably certain, are you reasonably certain? And the doctor doesn't say yes, he says that is my best estimate. He uses words like not uncommon for patients to need medications and physical therapy, maybe she'll need scans, maybe follow-up appointments, the treatment is customary and probably will be ongoing. He's asked for a ballpark cost. He said it would seem unlikely that a person would be able to establish that, meaning the maybe scans, maybe follow-up appointments, possibly injections from time to time, for less than $5,000.
For him to be precise about what might happen in the future. I mean, he's telling what is more likely than not that's going to happen. Are you looking for an absolute certainty from him?
Not an absolute certainty, Your Honor, absolutely not. He doesn't have a crystal ball, but the standard is reasonably certain. And this court, on at least 2 occasions that we cited to in our brief, Geico Indemnity Company versus DeGrandichamp and True Love versus Blount, specifically said possibly, maybe, could, might have a flare-up, language like that, might be getting these treatments is insufficient. And in DeGrandichamp, there was even a surgical estimate that was provided, much like Dr. Hall's $5,000 a year here. But because the surgery was only possible, that wasn't enough for this court, and that's what's required, the reasonable certainty. When he's squarely asked if he's reasonably certain, he says that is my best estimate. And on cross-examination, when he's asked, it sounds like you can't say to a reasonable degree of medical certainty, that's impossible for anybody to say. If it's impossible for Dr. Hall, it was certainly impossible for the jury in this case. And for that reason, he also says hopefully nothing more needs to be done. Hopefully she feels better and hopefully nothing more needs to be done. So I would submit to your Honor's.
Partners though use likely and possible.
I'm sorry, I didn't catch that.
Armadillo, the Florida Supreme Court's case in Armadillo. I mean, don't they say that you can use terms like possibly or likely?
It would, I would agree, Your Honor, but the problem with that is that it would still need to meet it would still need to be more probable than not. It would still need to be reasonably certain. And he's using words like maybe. He's using words like a ballpark of the cost, an estimate.
Well, I guess he was asked the question, doctor, folks that are of her age that have those types of permanent injuries drawing upon your education training, is there a reasonable certainty from your perspective that she will require further medical care and treatment over the course of her life to address these permanent injuries? Answer, yes. As I said, and then he goes on to talk about she has an artificial disc. So, I mean, to Judge Atkinson's point, there was some rehabilitation on this point. So isn't there testimony as to reasonable certainty then?
Well, the problem is that the actual treatment itself wasn't reasonably certain.
But you're never going to get, I mean, to Judge Morris's point, how are you in the future to get to these 100%, yeah, it's going to be this amount? I mean, the amount he was stating, that he testified to wasn't an extraordinary $20,000. I mean, it was a $5,000, which seems sort of nominal.
Certainly, yes, but still as to what the treatment would be and the cost, it would need to be reasonably certain. So to say, he's blanketly saying she'll need future care, well, what is that future care? That's what's unclear. That's what's the maybe possibly injections from time to time.
Yes, physical therapy, I mean, there were all sorts of things that he testified to.
Right, without a reasonable certainty, because it was impossible for him to say. That's, our position is that he didn't meet that reasonably certain
Does the
standard.
nature of the injury impact the testimony about future medicals? In other words, for example, in this case, we have an artificial disc that's been placed in the plaintiff's neck. Now, I'm not a doctor. That sounds ugly to me, okay? She's 25 years old. I mean, again, I'm not a doctor, but I can say that's gonna be a problem, probably, as opposed to a soft tissue injury that no one can really kind of sort of identify, and you get some vague statement of future medicals. Doesn't that make a difference? I mean, this is a very specific injury that is, on its face, says this is gonna be a problem.
I understand your point, Your Honor, and I agree. It wasn't a soft tissue injury or anything to that extent. The problem was Dr. Hall's testimony that hopefully nothing more needs to be done. That's what's confusing here and adds on to the element of it not being reasonably certain. And the jurors are left wondering, well, how much should I award? What should I award? He just says, maybe she'll need this, maybe she'll need that. And I can't imagine it would be less than $5,000 a year. It doesn't give them an actual number to go from, and I'm not sure where they derived the 292.5 from. And I don't believe that it's supported by the evidence, and that's our first point here. If I can move on to my next argument, unless there's further questions. Thank you. The next reason why Progressive was deprived of a fair trial concerns the evidence that Progressive attempted to put in that was denied in this case. So there were three different types of evidence that Progressive sought to use to defend this case. The first was plaintiff's prior primary care physician records. They spanned 6 years before the accident.
On those 3 points, where it was a proffer made after that evidence was excluded.
With respect to the primary care records, there was a binder of all of the records that were provided to the trial court. So the trial court had all of the primary care records.
Proffer made
Um,
of that evidence.
Counsel described the evidence and provided them to the judge. I'm not sure, other than she made arguments about what was in them.
Through anyone's testimony?
No, there's no testimony itself. Progressive intended to use the records themselves and argue from the records themselves.
On that evidence, can I make sure I understand the theory? The theory is not that there is some smoking gun where she had a disc problem before the accident. The theory is that this will just show how forthcoming she was in the past and prove the theory that if she was so bad off, she would have been more forthcoming post-accident. Isn't it?
That was one theory. The other was that this accident was not the source of her pain and suffering.
Explain that. What was to be found in this evidence that would have shown that it was from another source?
Well, sure, Your Honor. She was actually diagnosed prior to this accident with major depressive disorder, with ADD, with general anxiety. She was claiming pain and suffering, and she was awarded over $3 million in pain and suffering in this case. And Progressive was deprived of the ability to say she was uninterested in doing things. She was depressed before this accident. She had trouble sleeping. All of the things, all the ailments she complained of came from this accident. They existed 6 years before and onward and through.
The pain and her pain level?
Her emotional pain and suffering. She testified, Your Honor, that she
was sad before the accident. The jury should have found out that she was sad before the accident so that they could factor that into how much pain and suffering, non-physical pain and suffering she was suffering.
Yes, Your Honor. They didn't have a baseline to go off of. The plaintiff specifically testified that she had no prior injury whatsoever, nothing pre-existing. So she specifically testified, I have depression now, I cry 1 to 4 hours a day, I have trouble sleeping, I have nightmares, I don't laugh as much, I'm not interested in doing things anymore, and her before and after witnesses testified to that as well.
So,
Yeah.
okay, so are you saying that, so someone who has depression before, if they have an accident and it accelerates their depression, that they're not, that because they had depression before, they get nothing?
No, that's not what I'm saying, Your Honor. Certainly an aggravation.
Seems like it.
And I don't mean to, and I don't mean any disrespect, and I don't mean to sound that way. My point was that the plaintiff actually testified that she had no pre-existing injuries, that she wasn't seeking an aggravation of a pre-existing
Well, she
injury.
didn't, but was that in the context of whether she had pre-existing malaise or something? That was not, you're not contending that she hid an injury.
I'm not contending that. What I'm contending is that it insinuated to the jury that she didn't have these crying episodes, that she didn't have this lack of interest in doing things, that she didn't have the anxiety.
Can you point to the record about her answer? You said she answered a question, saying I didn't have pre-existing injury, and it sounds like you're insinuating that was less than truthful testimony because she had mental injuries before.
That's what I'm
What was the
arguing.
context of the question?
The context,
The context of the question, if I read it in the record, I'm with the impression that the question was referring to physical injuries.
to be honest, Your Honor, I believe physical injuries were discussed just before that. I don't have that page of the record in front of me to confirm, so it may be that it was in that context. I didn't take it that way, but it may be. I can't confirm.
I have a hard time seeing the probative value of this evidence in the face of unfair prejudice that might be resulting for it coming in. So in other words, I agree with the trial court judge's balancing of those two things. So, you're now the trial judge. Help me make a different ruling and explain what your ruling would be based on.
Well, sure, the argument was made that the prejudicial argument wasn't made with respect to her having these psychological issues, the ADD, those things. The prejudicial argument was made where there was some information about concerns of her boyfriend's sexual behavior, sexually transmitted diseases, things of that nature. Those were all redacted already from the record. So everything that was complained about to be prejudice was already redacted. So we were left with, she's making these significant pain and suffering claims. She's going to her doctor and complaining of everything under the sun, telling her doctor her whole life story every time she goes.
Was the primary care doctor treating her, the neck injury?
No.
Surgery?
No, but the primary care records from the accident onward were in evidence. The primary care records from before the accident were
She's the
not.
primary care physician for other things.
Right,
Which you wanted to get in and to show that they were relevant to her injuries.
right, Your Honor. Because they provide the jury with a baseline, how she was doing before this accident. Her before and after witnesses, as well as her, talk about how much she changed on a personal level, on a personality level. So Progressive obviously isn't in her head. Isn't able to challenge what these individuals are saying aside from records like this, because Progressive doesn't have any witnesses that knew plaintiff beforehand. So Progressive has these primary care records where she's divulging all sorts of details, complaining of all sorts of things to her doctor every single visit. After this accident, she's not complaining about her pain. She's not complaining about her emotional pain. She's not complaining about the accident.
Okay, so you're saying testimony from other witnesses, from friends, family, or whatever, you weren't able to cross-examine them on those points?
We were, Your
And
Honor.
and you wouldn't be able to use that information in the medical records and it as impeachment to any of them?
Well, no, those witnesses would have no way of verifying or knowing anything about those records. And using the records to impeach the witness wouldn't put the records before the jury when they're in the deliberation room for them to see and actually get a grasp on who Ms. Tran was before this accident. So Progressive was deprived essentially of its ability to defend against the
Okay,
pain
so
and
the
suffering
standard we
claims.
have to look at is an
No,
abuse
just
of
one
discretion.
second. You're about into your rebuttal time, so.
Oh, wow, okay.
It's your time, use it how you want to.
All right.
Ask your question.
My last question is how is this an abuse of discretion?
It's an abuse of discretion because, like this court indicated in the Pettigrew case, State Farm versus Pettigrew, when a court improperly excludes evidence that substantially interfered with the party's ability to present a crucial element of their defense, that's an abuse of discretion and that requires a new trial. And I will reserve the remainder of my time and arguments because this one went by way too fast for rebuttal.
You've still got 5 minutes because I warned you ahead of time.
Okay, thank you so much, Judge Mills.
Good morning, Your Honors. Jeffrey Bird for the appellee. I was also trial counsel before the lower court. To your point, Judge Morris, this is not a run-of-the-mill case. It did involve a 25-year-old young lady who essentially had a head-on crash at 70 miles per hour with her vehicle erupting in flames, and thankfully she was able to escape before burning to a crisp as her car did. In terms of the issues that have been raised in oral argument, I feel that on behalf of the appellee, I thoroughly briefed those issues, so unless the panel has any.
What was the prejudice? So you said, so we have, Judge Morris talked about our standard review, it's an abuse of discretion, it's prejudice versus probative versus prejudice. And counsel for the appellant said, any of the prejudice was eliminated by the redactions. Is there just like a per se prejudice because it's a constitutional right of privacy in medical records?
Well, to Judge Smith's point as well, there was never a offer, there was never any explanation given to the judge as to how these.
You didn't answer my question, or you're saying.
No.
I mean, I get that, but what was the prejudice?
There was no prejudice, there was no proffer, there was no explanation given by Progressive at
Why was it
trial.
excluded?
It was.
If we find if we find it probative to a theory or defense, that here would be the theory of defense is, the damages shouldn't be as high because some of this malaise that she'll suffer for the rest of her life was pre-existing. Why not introduce it?
Forgive me, I misunderstood your question. I thought you were talking about prejudice to Progressive by having it excluded. You meant prejudice to the plaintiff by having it included. I apologize, I misunderstood your question. So to that point, the records simply weren't relevant to a neck injury case. This notion that's being advanced today regarding malaise candidly wasn't set forth in the post-trial motion nor briefed. So this is new and novel that I'm hearing today.
So what I understand from the briefing was that there was one distinct theory that I led with when I asked her questions, which is, this shows that she was much more forthcoming with her primary care physician throughout the course of her pre-accident medical treatment, and therefore that has some bearing on whether or not she really is suffering all these maladies, because she didn't mention it to her primary care physician after the accident. That's one theory that was explained in the brief, unless I'm reading it.
That may be a theory, but that wasn't borne out by the evidence. The excluded pre-accident records, let's be clear, the post-accident records came into evidence. The
Yeah.
pre-accident did not, related to GERD, ear infections, things that had nothing to do with a neck
The
injury.
theory is, well, if she was so forthcoming about every single little thing when she was a doctor, and now she's silent about these things that she's supposedly testifying to the jury about when she goes to her primary care physician, is that somehow probative?
No, sir. She was very clear at trial that her primary care doctor emphatically told her following the crash, I don't treat people for auto accident cases. So I hope I'm answering your question, but Judge Barbas is quite extensive, by the way, nearly 30-year veteran of the bench. I believe he was former chief judge of the circuit court there in Tampa. But he is the one that engaged in this discretionary analysis and quite candidly told counsel there's no relevance to this pre-accident medical history. Had breast augmentation, had GERD, had ear infections, had nothing to do with neck infection.
Go ahead.
Yeah, so So the test is, it doesn't just have to be probative. I mean, the test is, does the probative value of that evidence, is it outweighed by unfair prejudice? And the court ultimately determined that the unfair prejudice outweighed any probative value that that evidence had.
I
Correct?
agree.
Okay.
And ultimately, that's an exercise of discretion for Judge Barbas. And he was very thoughtful. He explained his analysis both during trial and post-trial at the post-trial hearing. So I don't believe that
I'm
this.
asking what the prejudice was to the plaintiff.
Prejudice is, what would be the merit in putting before the jury things about breast augmentation and GERD and ear infection?
I'm asking what the prejudice would be.
Well, the prejudice is that you do have a constitutional right of privacy as to things that have no bearing, no relevance to the issues, the medical issues
The
being.
prejudice to the plaintiff would be her constitutional right of privacy being violated.
Yes,
Is that
sir.
what you're saying?
Yes. Does the panel have any further questions? Respectfully, there weren't proffers made, to your point, Judge. There wasn't even an articulated explanation. There was no objections to the plaintiff's presentation of evidence or argument as to that evidence. They have argued that the verdict awarded by the jury was contrary to the manifest way of the evidence. But indeed, I had asked for $16.7 million in damages, and that which was awarded was substantially less. There was not even an objection made to my closing argument that was very clear and specific as to how it was based upon the evidence presented at trial. So there wasn't even a preservation of this notion that the verdict was against the manifest way of the evidence in a setting where there was no objection.
Confused by that argument in the brief that because there was no objection to the description of the calculation advanced by the plaintiff in the closing argument, you can't post-trial move or make a motion made.
I guess to be clear, my position is Progressive's trial counsel didn't have an issue with the arguments being presented. Clearly, their appellate counsel has. Their appellate counsel wasn't at trial.
Arguments, I mean,
I'm
they
sorry.
didn't, you're not, I mean, are you saying because they didn't make an objection in closing, they're precluded from arguing that here on appeal?
I'm not saying it's
That's
a
it.
bar, if that's your Honor's question, but I do think it's a relevant factor in considering the merits of their argument.
Okay.
I hope I answered both of your questions in that regard, but let's be clear, the defense didn't even give the jury guidance from their perspective as to the relative value of damages. So not only do they not object to what the plaintiff has to say about the evidence and the value of the damages, they didn't present the jury their own calculations as to what, other than to say it should be zero. So in a setting where the jury is only given guidance by the plaintiff, was not given guidance by Progressive, I don't believe that the jury's verdict was excessive in as much as it was a quarter of that which the plaintiff sought. And I don't believe that the evidence, the record would show that Progressive met its very heavy burden to show that Judge Barbas abused the discretion in denying their motion for a new trial. They also didn't move for a directed verdict as to any of these claimed issues with respect to future medical damages and future employment damages. Judge Smith, to your point on the issue of those damages as it relates to the medical, you are correct. The Armadillo case talks about possibility. I also briefed the case of White v. Westland, but let's be clear, there was not any argument or evidence couched in terms of possibility. So I submit that those cases are relevant even if there had been testimony expressed in terms of possibility. But in this case, I asked 3 times, I counted it in the record again this morning, just to make sure I'm correct in this regard. I asked the doctor to express his opinions within a reasonable degree of medical certainty 3 times. Those damages that you're reasonably certain she'll need in the future, and to your point, Judge Smith, or maybe it was you, Judge Morris, forgive me, $5,000 a year, it's hard to say that that's excessive in a setting where he very specifically detailed 5 points as to what that future care would be. Follow-up visits, follow-up scans, more medications, physical therapy, and then potentially injections as well. And this is somebody who had already had multiple injections. She had already had a different procedure called an ablation where they go in and burn the nerve. and then ultimately came to have the spine surgery at a very young age in life. She had a 58-year life expectancy thereafter. So we believe that the evidence well supported the verdict, but furthermore, the absence of any objections to the argument presented in closing further supports that Progressive's trial counsel didn't view that we were presenting damages not based upon the evidence. So the notion that it's contrary to the manifest way of the evidence is inconsistent with the manner in which Progressive tried the case at trial. So unless the panel has any further questions, I'll stand on the brief. And thank you for your time and consideration.
Thank you. You have 5 minutes.
Thank you, Your Honors. May it please the court again. A few things I want to touch on with respect to additional evidentiary calls that were made in this case. There were also employment records, plaintiff's employment records that were excluded. It was records from a prior employer, Chick-fil-A, as well as records from the employer where she was currently working at the time of trial, Nationwide Title. Within those records, and frankly, there was no proffer with respect to this. However, counsel argued to the court the contents of the records. Essentially, the Chick-fil-A records had where Ms. Tran was disciplined for cash shortages.
How does that affect, in other words, the theory would that she would never be able to hold down a job?
The theory was so the standard is the jury is entitled to consider all relevant factors with respect to future earning capacity. That can be habit, which is, I think, where the judge was. I'm sorry?
Did she get fired for that?
From Chick-fil-A, I'm not aware of her getting fired because of that. She had
So
a
many
very
of these employment records, because you complained about the title company, that she didn't work to the very end of the day, and she made the same
Sure.
mundane errors over. Did she ever get fired for any of these things?
Not to my knowledge, no. That
Well,
was
if she didn't get fired, then who cares?
Well, the fact of the matter is that plaintiff testified that, so her future, or her earning capacity claims for the future were based off of her past missed work times. And she was testifying that she expected her future, this is on 2304, plaintiff expects her future to look like her past. And Progressive was trying to refute that, to say, well, your past, you're being docked for being late, you're clocking in without working.
Job.
I'm sorry?
Past was she has a steady job.
She had a job where she's making so she was telling the jury that she was unable to focus at work. But in the context of the records, and again, this was the PCP records too with her ADD diagnosis, she was having these issues before this accident. So the genesis of this is, it's not the accident that caused her to have these troubles at work. You can see she's having them before the accident. You can see she continues to have them. And her past, if it's going to look like, if her future is going to look like her past, it will continue in the
So
future.
the theory doesn't have to be that she would never be able to hold down a job. The theory would be that the jury would essentially reject altogether any impact the accident had on her capability to earn a living, because she already had trouble focusing. She already had difficulty.
Right, well, it would certainly be relevant to that inquiry. What weight the jury gave it is obviously a question for the jury. She testified that the accident caused her, she could only fulfill her obligations at work 20 to 30%. So this goes to refute that. She indicated, in her primary care records, and I'm jumping a little bit because it dealt with her employability. In her primary care records, in December of 2019, so less than 2 months before this accident, she's reducing her time at her then job, which was at Michael's Craft Store, by down to 2 times a week because she's having trouble focusing and her ADD is acting up. So these are all things, when you take the primary care records, you take the prior employer records, they go to refuting pain and suffering, and they also go to her wage loss claims. Even her past wage loss claims, was she really missing work just for medical appointments, or was she missing work because, and reducing the amount of time she worked because of her ADD? She missed 6 months right after the accident of work. claiming she couldn't work. And was it the accident, or was it really she was having these issues 2 months, just less than 2 months prior to this accident? All of that was relevant, and the trial court abused its discretion by excluding it. The weight of it, what the jury did with that, the jury could have disregarded it, but that's in the province of the jury, not the trial court. Additionally, lastly, I want to touch on the last issue we addressed in our brief, which was the evidence of personal injury protection. Counsel ahead of time didn't agree not to handle it post-trial, decided not to handle it post-trial. So Progressive had to present evidence during trial, as your honors know, to support its affirmative defense of collateral source setoffs. Specifically, it was the PIP benefits. Plaintiff admitted in discovery in her request for admissions that PIP paid benefits, that she wasn't responsible for what PIP paid. So she didn't owe that portion of her medical benefits.
I'm gonna let you finish your thought, but you are over time right now.
I apologize. The court wrongfully excluded that. It was clearly an admission of a party opponent, not attorney-client privilege. All in all, Progressive was deprived of a fair trial in that the jury awarded evidence that wasn't supported for future economic damages with reasonable certainty, and that Progressive was deprived of defending the matter substantially with the evidence that was excluded here. I thank you all for your time.
Thank you. Thank you both very much. Well argued. We'll take a